Welcome to the other side of Lucy Letby. In episode 54, we're going to continue reviewing this Court of Appeal judgment that denied Lucy Letby the right to appeal. And we finished off last podcast on ground one, the judge's ruling on Dr. Evans' evidence. This is Justice Goss, who was the judge in the Letby trial. It's 106, paragraph 106 of the Court of Appeal ruling, and it says, having heard argument on the 9th of January 2023, the judge gave his ruling in writing on the following day. He fairly set out the respective contentions of the parties, the matters they relied on, and the relevant law. He then expressed his conclusions. In relation to the respective submission, it is, as the prosecution submit, important to contextualise the role of Dr. Evans at the various stages of the investigation into the events. So here we are with Justice Goss immediately attempting to separate Dowie Evans' role, and by doing so somehow create a difference in the facts that he established as an investigator from the facts that he put into evidence as an expert, even though they're identical, except for the occasions during the trial when he changed his mind on the stand. But of course, this makes no sense whatsoever. Dr. Evans was a paediatrician. He had no expertise as an investigator. So his expertise as an investigator was to act as a paediatrician. And his expertise as a witness was to act as a paediatrician. Pediatricians are not trained in the art of investigation. That's how I see it. As regards to the facts which Evans created by his evidence, the facts were not altered by his role as an investigator. In fact, they were established by his role as an investigator and conveyed to the court by his role as an expert. They are, for me, indistinguishable. At the outset, it goes on, there was a large number of incidents that merited investigation. What's that got to do with anything? The number of incidents, 1 or 100, has no bearing whatsoever on a review of the outcome of those incidents. There needed to be a review and sift in order to identify those cases in which there was no identifiable medical cause or some causative negligent act or omission which, prima facie, were cases in which a baby suffered an event or collapse, in some cases dying for no apparent reason. The offer of Dr. Evans to conduct that initial review for a sifting process was not inappropriate or unreasonable in the circumstances. But sifting is the wrong word for me here, because the court prevented reporting during the trial, including the work of Rachel Aviv. And Rachel Aviv made it very plain that when she spoke to Dowie Evans, and Dowie Evans has not said that Rachel Aviv misquoted him, he was not sifting through cases looking for problems in the care of the babies at the Countess of Chester Hospital. He was sifting through the cases to see if he could construct malice and not find malice. And I'll just read you the section of the Rachel Aviv article that to me makes that claim irrefutable. That summer, Evans, who was 67 and had worked as a paid court expert for more than 25 years, drove 3.5 hours to Cheshire to meet with the police. After reviewing records that the police gave him, he wrote a report proposing that baby A's death was consistent with his receiving either a noxious substance, such as potassium chloride, or more probably that he suffered a collapse as a result of an air embolism. Later, when it became clear that there was no basis for suspecting a noxious chemical, Evans concluded that the cause of death was air embolism. These are cases where your diagnosis is made by ruling out other factors. That's a quotation from Evans, which is factually untrue. You cannot go into a coroner's court and propose a mechanism of death. You have to tell the coroner precisely why the person died. And if you can't, that becomes or can become an open verdict. And you can have death by natural causes with cause unknown. If there is insufficient evidence to determine the exact cause or circumstances of death, if the evidence does not fully or clearly explain the cause of death and circumstances of a death, and there's genuine doubt about the circumstances surrounding the death, this happens a lot in supposed cases of suicide, and there are many famous cases where open verdicts were returned because the jury in the coroner's court could not determine the cause of death. So whereas it may not be satisfactory for the family, making shit up to explain a death is not part of the process. And Rachel Letby carries on that Evans had never seen a case of air embolism himself, but there had been one at his hospital about 20 years before. An anaesthetist intended to inject air into a baby's stomach, but he accidentally injected it into the bloodstream. The baby immediately collapsed and died. It was extremely traumatic and left a big scar on all of us, Evans said. He searched for medical literature about air embolism and came upon the same paper from 1989 that J. Ram had found. There hasn't been a similar publication since then because this is such a rare event, Evans told me. And whereas it's probably true that there are not as many papers structured like the Lane-Tanswell paper, in that he tried to accumulate all the cases in the world into one short study, which is called a case series report. There are multiple papers, probably hundreds, which construct a much more detailed, overarching view of venous air embolism or pulmonary air embolism that Evans pretends doesn't exist in this interview with Rachel Letby and in his evidence to court. It's necessary for Evans to maintain this myth of we don't know that much about air embolism, because this gives him the ability to essentially invent any symptom, observation or finding that he wants. Putting the words neonatal air embolism into the PubMed search engine, so this is the National Library of Medicine from the United States, only one of the medical search engines in the world, gives 275 papers, including the Lane-Tanswell paper and the new Lane-Tanswell paper, which is a comprehensive rerun of the 1989 paper and includes 117 cases, none of which had any skin discoloration in relation to venous air embolism, which is new evidence. And Rachel continues on that Evans relied heavily on the paper in other reports that he wrote about the Countess deaths, many of which he attributed to air embolism. Other babies, he said, had been harmed through another method, the intentional injection of too much air or fluid, or both, into the nasogastric tubes. This naturally blows up the stomach, he wrote to me. The stomach becomes so large, he said, that the lungs can't inflate normally and the baby can't get enough oxygen. When I asked him if he could point to me any medical literature about this process, he responded, "There is no published papers regarding a phenomenon of this nature that I know of." And that's because it doesn't exist. Now, Evans has since tried to wriggle his way out of this by saying that this was not the cause of death in the baby, but it was the cause of destabilization in the baby. But that won't rub, because all of the babies were not as stable as Evans said they were. And none of the backup evidence from histology to radiology is sufficient even to make it into court, in my opinion. Now, Justice Goss carries on in paragraph 106 to say that the offer of Dr. Evans to conduct that initial review for a sifting process was not inappropriate or unreasonable in the circumstances. Well, he didn't offer to do it for free. He sold his services in a commercial transaction, which is in itself a conflict of interest. The more cases Evans could review, the more money he could make. And there's no getting away from that. And Justice Goss carries on, missing the point of the whole thing, saying that his initial shift identified incidents relating to a large number of apparently unexplained incidents relating to babies on the unit, and his preliminary view as to possible mechanisms responsible for some of the events. Well, the problem with that is that Evans had 60 cases, supposedly unexplained, unexpected collapses in the neonatal unit. And despite the fact that Lucy Letby was not present when he said she was present, Lucy Letby was the only one held responsible for any of these collapses. When it's obvious to any doctor reading this stuff that many other factors played a part in the death of these babies, all of which were outlined in the Royal College of Paediatric and Child Health report, which conveniently Justice Goss doesn't have to consider because he ruled it inadmissible. And this is where we get into these logic traps, whereby simply controlling the narrative, we can control, if not the facts, the perception of the facts. And Justice Goss goes on to say that I accept the prosecution's submission in relation to the reasonableness of the approach taken by Dr. Evans in this regard, and the fact that this did not amount to inappropriate partiality or lack of independence. The police were happy with Dowie's work, and that made Dowie happy. Words from his own mouth. It's plain, therefore, that Dowie Evans perceived his role as different from Justice Goss. And he continues, therefore, again, it was not, in my judgment, unreasonable or inappropriate for Dr. Evans to provide some direction and judgment structure as to the way forward in relation to identified cases. He had the necessary knowledge and expertise. Direction and judgment structure. What the hell does that even mean? But it isn't a passive process. And report writing and reviewing is a passive process. Evans is very much engaged in structuring and applying judgment to which cases he considers unexpected and unexplained, and therefore he's constructing the entire case against Lucy Letby. It is frankly naive, in my opinion, to say that Evans merely provided some judgment and some structure. He provided all the diagnoses, which in medicine is everything. And Justice Goss carries on, his role did not amount to acting as an investigator or director of the investigation to the extent that it precluded him from being an expert witness in the case. Now, this is where we take logic back about 2,000 years to Plato without Plato. In Plato's dialogues, Socrates often argued with himself. Because he was Socrates, Dowie Evans is incapable of arguing with himself or anyone else. He's right and everyone else is wrong. Almost all Western philosophy has moved in the opposite direction. We have to take our biases and our prejudices and we have to put them to the test of falsification. Dowie Evans, on the other hand, is going to go into court and use all the guile he can to uphold his belief that Lucy Letby was guilty. And we know that because he did not offer a single alternative differential diagnosis for any of the babies, and in order to find malice in Letby's actions, he had to ascribe actions to her which she did not or could not commit, such as injecting baby C with air into the stomach on a day she wasn't at work. That goes to the heart of the structure of his investigation, otherwise known as Operation Hummingbird. Evans did not act like an expert witness in this case because he couldn't act with impartiality within the structure of an investigation that he created. And in every one of the cases, he was clearly partial, not impartial. And then he talks about the shift patterns, which are junk, and the other evidence by the experts that Evans advised the police to choose, which is junk. And I'll just give you an example of what I mean by junk. Take Owen Arthur's unusual finding of a line of gas in front of the spine and set it beside this, which is a description of one of the investigations using radiology into one of the cases that I cited earlier as part of a systemic review in one of the many papers from PubMed. When air embolism occurs, air is identified in the heart or major blood vessels and rarely in the brain as a consequence of air injury. There may be sudden cardiovascular collapse or sudden deterioration in oxygenation with refractory hypotension. Hence, in many cases, the diagnosis is in the study post-mortem. Ultrasound at the patient bedside is a fundamental tool that is currently used in intensive care, but not at the Countess of Chester Hospital. Since the implementation of point-of-care ultrasound programs in different NICUs, several cases of air embolism have been reported, including survivors. The objective of presenting this case is to demonstrate how the complication was documented by ultrasound in an extremely preterm infant who suffered sudden collapse after instrumenting the umbilical vessels, that is, putting in arterial or venous lines. And this case is a male neonate, product of a 21-year-old mother's pregnancy with poor antenatal care. He was born vaginally at 30 weeks of gestation with a birth weight of 1,360 grams. There was premature rupture of membranes of indefinite duration. He required advanced resuscitation maneuvers at guards 5 to 8 with intubation, administration of surfactant and placement of umbilical catheters in an emergency hospital. At 6 hours of age, he was transferred to a level 3 unit. A blood count was reported with 12.4 grams per deciliter of hemoglobin. That's a little bit of anemia. 42% hematocrit, 7,390 leukocytes, 47% segmented, 50% lymphocytes, and 208,000 platelets. Antibiotic coverage was given with ampicillin and amikacin, and then appropriate transfer was made. So upon admission to the NICU, he was found hypothermic, pale, hypotensive, and with bleeding from the orogastric tube. Mechanical ventilation was continued with a peak expiratory pressure of 23/7, which is very high, and 60% oxygen. So a sickly little baby. At 6 hours of age, ultrasound was performed, in which transitional circulation, so that's the movement of the circulation of the baby from in utero to ex utero, with increased pulmonary vascular resistance, that's a reduced ability to move deoxygenated blood to the lungs. Patent ductus arteriosus, that's a little right-left shunt inside the heart, again pulling blood away from the lungs. And a patent foramen ovale with bidirectional shunt were observed, with low cardiac output and hypotension Pulmonary lung ultrasound showed adequate pleural sliding, so the lungs were moving well enough, lubricated between the pleura, but it generated coalescent B lines and a white lung with a collapsing bronchogram. Technical stuff that just means that there was fluid on the lung that was probably not visible on an X-ray. So they expanded the fluid volume and gave some adrenaline. And as part of their care, the umbilical arterial line, that's the line going through the little belly button attachment into the artery that you can then properly measure the oxygenation of the blood, and the venous catheter were inserted. Minutes after this procedure, hemodynamic, that's the blood pressure, deterioration occurred. And despite treatment, which included blood products, more adrenaline, more respiratory support, and more ultrasound studies. And the ultrasound showed that both sides of the heart, left and right ventricles, were obstructed and ruled out pneumothorax and pleural effusion, meaning there was no source of air leak into the circulation from the mechanical ventilation. And they found a small right subcapsular hematoma in the liver, but they also found an artifact known as the comet sign. And basically the comet sign is when the bubbles of air in the blood from the embolism that break apart send back multiple echoes. And because the resuscitation continues and more air is added into the lungs, there is no diminishment of this sign in the heart over time. It looks as if there's a comet just sitting in the sky. And that is how these people were able to diagnose air embolism. Just contrast that with how Dowie Evans diagnoses air embolism. But Justice Goss thinks he's a reliable witness. He wouldn't know one end of a point of care ultrasound from the other. In fact, he didn't even know how one of the fluid pumps worked in the neonatal unit. That's how much of an expert this guy was. And in that case that I've just cited, despite all the information they had, they could not detect the source of the air and assumed that it was surely from the messing about with the catheters, simply because the deterioration happened at that time. The deterioration of baby A happened within minutes of starting an infusion in the PICC line. The PICC line was immediately removed, but fluids were given by another line. And the only other line present was the umbilical venous catheter line in baby A that was in the wrong place. But if these experts with their ultrasound and all of their imaging capabilities can't say where the air came from, they can only assume it came from the umbilical venous catheters or arterial catheters, how can the Countess of Chester Hospital, via Dowie Evans, know that Lucy Letby injected her into a baby? He can't. This is the difference between real medicine and real reports and Dowie Evans and fake reports, which Justice Goss thinks is okay. And I presume because Justice Goss is a judge, that makes it okay. But I imagine that Dowie Evans' reports would make for very sorry reading. And Justice Goss carries on to laud Evans for spotting two other cases. These were the insulin cases, BBF and BBL. But they actually found 3 insulin cases, according to Professor Hindmarsh, but one of them was dropped. And I have read Dr. Hindmarsh's report that claims that the third baby also suffered from exogenous insulin administration. I wonder why no one was prosecuted for poisoning that baby, because Professor Hindmarsh is very certain that the baby was poisoned. which is another Letby mystery, isn't it? But the problem with the insulin cases, as we will ultimately find out, is that Evans was not expert enough to know how to read a lab report, because clearly the lab report released in the farewell inquiry on baby F is a contaminated sample, and that will have to be addressed at some point. And he's also inexpert when it comes to interpreting abnormal insulin and C-peptide ratios in preterm babies, as in the case of baby L. If baby L suffered from exogenous insulin poisoning, other babies have too, because these findings in baby L are similar findings from other studies into insulin secretion in preterm babies. Surely this is a problem, because Justice Goss quotes the inclusion of baby F and baby L by way of Evans' expertise to measure the standard of Evans' expertise, and use that standard to continue to include his evidence in the trial. But the standard is clearly not what Justice Goss understood it to be. And in particular with baby F, it's a basic mistake when it comes to reading any blood report from any laboratory. The reading for glucose on the same sample that the insulin and C-peptide were tested on reads 999, which either means it's 999 millimoles per litre, or it's some kind of error code from the analyzer. But it doesn't matter. That sample could not be used in clinical practice. And Justice Goss carries on, these matters are not of themselves determinative of the question of the appropriateness of Dr. Evans as an expert witness, but they are matters relevant to the complaints giving rise to the application that he should in effect be disqualified as an expert witness in the case due to the lack of independence and credibility. So Justice Goss has taken the opinion that the matters are merely relevant, but not determinative. And like all things in science, relative relates to the position of the observer. So quite clearly in his judgment, Justice Goss puts a great deal of weight on the findings of poisoning in baby F and baby L, not only to prove that Letby is a criminal, but also to prove that Dowie Evans is a reliable expert witness. And the two words are independence and credibility. The finding of these two cases are proof of Evans' independence and credibility, when I argue that they're the exact opposite. And Justice Goss carries on, in relation to the evidence generally, and particularly under cross-examination, and the complaints that he was subjective, emotive, dogmatic and biased, both in terms of the content of his answers and the way in which he behaved, I accept that at times Dr. Evans, particularly when asked repeated questions on a topic to which he believed he had given an adequate answer, engaged in a formal argument, and on occasions he appeared to be frustrated by the persistence of the questioning and or was dismissive of suggestions. He was often prolix and would answer a question by an explanation rather than directly. So back to the old Latin again, prolix, from the Latin prolixus, meaning stretched out, or in more modern parlance, long-winded, verbose, wordy, overly complicated, and likely to cause the jury to lose attention. However, Justice Goss goes on, none of these instances, in the context of robust cross-examination or otherwise, whether taken either individually or collectively, with or without the criticisms made of his alleged role and attitude, provides sufficient evidence meriting the exclusion of the evidence of Dr. Evans on the basis that he has failed to act to a standard and in a way required of an expert witness. They are all matters that are capable of being relevant to the assessment by the jury of his evidence. Back to the jury then. We need experts, but we don't need experts. We need experts to tell the truth, but we don't need experts to tell the truth. This discourse goes on. It is for the jury, for them to determine, as with any witness, his reliability, having regard to all the evidence in the case. Similarly, I decline to exclude the evidence under Section 78 of PACE. The admission of this evidence would not have such an adverse effect on the fairness of the proceedings that the court ought not to admit it. The matters raised have been and remain capable of being addressed within the trial process and can be subject of comment and submissions to the jury on all the evidence placed before them. That would be the constellation of evidence and circumstances, including the countless examples of non-diagnostic skin discolorations put into evidence by multiple witnesses, but not recorded at the time by many of them, which evidence only became important when it acted to confirm Dr. Evans' misplaced belief that patchy skin discolorations were in some way associated distinctly to cases of air embolism when they clearly are not. Accordingly, the primary applications of the defence are refused. The application to adduce the evidence of the adverse judicial comments by Jackson L.J. in the relevant decision on the papers, which is not opposed by the prosecution, is granted. It is relevant material for the consideration of the jury in relation to the assessment of the compliance of Dr. Evans from his obligations as an expert witness. Who needs rules? The jury can decide. It will be necessary, according to Justice Goss, to identify the way in which this is to be done. How do we undo the Gordian knot that was Evans' clear prejudice, Dr. Bowen's endless persistence in not blaming the staff for obvious mistakes? It is to be hoped that this can be achieved by agreement. If not, then I will deal with it as a case management issue. And Justice Jackson's very pertinent and accurate comments are merely adduced. That means piled into the general argument, which the jury was free to decide on their own. So on the face of it, we have here allegations of bias, lack of expertise, and what's worse, evidence of both. Again, in the case of BBA, the evidence was that BBA went 4 hours or longer without dextrose, which was reduced by Darry Evans to a couple of hours, making that a biased comment and altering the facts in evidence to the detriment of Lucy Letby. Just one example of many. But how can a jury know if it's possible or not for a baby to die simply by running out of glucose? It's perfectly reasonable for an expert to say that. But why don't we listen to other people and what they think about Evans' ability to pick up on even the most basic observations that a doctor should make in any case. This is Dr. Richard Taylor speaking about baby food and glucose to baby A. Yet that's precisely what Evans did. And that alone is sufficient to prove he was a biased or ignorant and therefore totally unsuited expert witness in this case.
Your insulin test result, which went to Liverpool, and the test result shows slightly elevated cortisol level, a sky-high insulin level, a low C-peptide or a normal C-peptide perhaps, but also what was missed, an incredibly high blood glucose value. And that was completely inconsistent with the clinical findings on the baby, where bedside glucometer measurements were extremely low. And in fact, that was why the insulin level was measured. And yet the blood sample, which contains which was used to analyze the insulin, actually read 999 millimoles per liter glucose, flagged high and verified. That information appears never to have come up in court. It was not mentioned by the prosecution experts. There was no defense report, and it was never even brought up in court. Why?
Why indeed? Why indeed? This is the most basic part of doing a report, looking at all of the clinical evidence that you have, checking it line by line to make sure there's no mistakes. That's the basic thing you want from a medical expert, and yet Darry Evans was incapable of doing that. It's the equivalent of a mechanic not checking your oil pressure. Brake lights or tires before you go for an MOT. Competent and reliable expert witness or medic of any description would not miss the glucose level, particularly when it's glucose that is the subject of the inquiry. It's rookie. So now we have the appeal court judge's opinion on the opinions of Justice Goss about the reliability and detached indifference of Darry Evans. Paragraph 107, the applicant's submissions in writing effectively repeat those made to the judge. In his submission to the court, Mr. Myers does not suggest the judge applied the wrong test with respect to admissibility, or that the judge misunderstood the relevant principles of law to be applied. And this is the problem with this whole system of experts in the court. The judge who is making the assessment on the reliability and knowledge of Darry Evans, the expert, has no knowledge on which to make that decision. So we're in another logic doomed. Instead, having initially said that the judge had reached an unreasonable conclusion, Mr. Myers simply submits that the judge's decision was wrong. Thus, the judge was wrong, he says, not to direct the jury to disregard the evidence of Dr. Evans. This was because Dr. Evans lacked the necessary expertise to give expert evidence in the trial. He took the role of investigator, and his evidence did not conform with the standard required of an expert witness. Various passages from Dr. Evans' evidence, namely those outlined to the judge, were cited in writing, this is to the appeal court, in support of the submission that he conducted himself in a dogmatic manner when giving his evidence. Any further evidence of Dr. Evans should have therefore been excluded, with the jury directed to disregard the evidence which had been received. So the dog is just fetching the same bone here. We move on to paragraph 108. Mr. Myers accepts Dr. Evans had experience of neonatology, but maintains his submission that he was not a neonatologist. It was not a discipline in which he was an expert, and neither was it. Further, he had not been in full-time clinical practice since 2009. Astonishing. He's the only witness that Cheshire Police could get. Dr. Evans had in fact been an investigator in this case from an early stage. This was a more substantial criticism and raised questions as to his impartiality. Though the evidence of Dr. Evans was corroborated by other doctors such as Dr. Bowen, it is submitted that Dr. Evans set the tone of the investigation, and the evidence of Dr. Bowen was based on the evidence of Dr. Evans. Moreover, the exercise of assessing the competence of Dr. Evans could not be gauged by the consistency of his evidence with that of other expert witnesses. And whose fault was that? the defence, because they didn't call any other expert witnesses against which to gauge Dr. Evans. And then in paragraph 109, on behalf of the respondent, Mr. Johnson describes the applicant's argument on this and other related grounds, that is, ground 2 and 3, as reductive. That is, they seek to isolate one narrow issue in the case from all the rest of the evidence, and to make each ground of appeal from one issue to the exclusion of the consideration of all the others. But he submits, in this extraordinary case, context is everything. The fact that Dr. Evans volunteered to assist the police did not render his evidence inadmissible. He dealt with an extraordinary volume of cases. The case of the insulin babies, baby F and baby L, which he identified, was his 60th review. Paragraph 110, when addressing the submission that Dr. Evans lacked the requisite expertise for giving evidence in a case like this, Mr. Johnson poses the rhetorical question: who would be better placed to advise on what may have been happening in a neonatal unit than someone who had been dealing with these facilities for 50 years? Dr. Evans did have the requisite expertise. If he did step over the line in relation to one baby, baby C, in which he gave his opinion on the cause of the baby's collapse for the first time in the evidence to the jury, that did not invalidate his evidence generally. Dr. Evans was in a position to give information outside the knowledge of the court. He held concurrent registration with the General Medical Council and had the requisite experience. The reason Dr. Evans did not classify himself as a neonatologist was because when he developed the specialty in South Wales, neonatology was a subspecialty, so he didn't train as a neonatologist. Each of these features was addressed by the judge, as was the question of reliability. Reliability can only be measured by reference to other admissible credible opinion. Looking at each of the requirements of the law, the evidence of Dr. Evans was admissible. In the oral submissions of Mr. Myers, Mr. Johnson said the shortcomings of the evidence of Dr. Evans were not explained. The case relied upon by the defence in their written submissions were obviously distinguishable from the facts of this case. So let's just break down that last paragraph again in this podcast before we move on to the appeal court discussion on the grounds of appeal and the reasons why they turned them down. So Mr. Johnson poses the rhetorical question: who would be better to advise on what may have been happening in a neonatal unit than someone who had been dealing with these facilities for 50 years? That is what we call appeal to authority. One of the oldest logical fallacies known to man. Because he's been doing the job for 50 years, no one knows how to do the job better than him. It's as simple as that. That is not a rhetorical question. It's an invitation to partake in circular logic. Let's look at 50 years ago. That would be 1975, which is something of a coincidence because that was the year that neonatology became a specialty and not a subspecialty. So practicing neonatologists have experimented, innovated, thrived, retired, and died in that time as specialists. Yet Dr. Evans is qualified, having worked his entire career not being a neonatologist when he could have been. He likely never used CPAP or high-flow nasal cannula, enhanced brain imaging, point-of-care ultrasound, and he missed the whole period between 2009 and 2020 when in the UK, tertiary units increased their admission by 5.6%, while level 2 and level 3 units decreased theirs by almost 10%, meaning that the hope for outcomes available in level 3 units have already rendered general pediatric consultants as irrelevant to neonatology during the time that this man retired. He says that Dr. Evans was in a position to give information outside of the knowledge of the court. In other words, Dr. Evans was an expert, and he was an expert because he was an expert. He held concurrent registration with the General Medical Council. How did he get that registration, which normally requires validation as well as registration? Validation means that you're up to date to work in your specialty, whereas registration just means you're still a member of the club, but you've long since hung up your 9-iron, and you definitely can't park in the captain's space. The reason that Dr. Evans did not classify himself as a neonatologist is very simple. We've already talked about it, because he wasn't one. So Mr. Johnson hasn't given us any reason why Darry Evans was qualified to give evidence as a neonatologist when he wasn't a neonatologist on matters relating only to neonatology and nothing else. But he wins the legal point that the defence failed miserably when they didn't call their own expert witnesses. To me, that was a suicide mission. You know that the experts that are lined up are not reliable or unbiased, and what do you do to counter that? You rely on them. So it's easy to see what the judges are going to say in this matter. According to the law, Dr. Evans was a good enough witness because Justice Goss said he was, and the defence agreed because they didn't supply an alternative witness. And Lucy Letby rots in jail, and the families still don't know what happened to their babies. And this is 2025, not 1025. Let's just have a quick look at Rule 19.2 of the Criminal Procedure Rules, which say that the overriding duty of an expert is to the court, which establishes that an expert's primary duty is to have the court achieve the overriding objective of providing unbiased opinions within their area of expertise, and that the duty overrides any obligation to the instructing party, ensuring that experts prioritise truth and accuracy over advocacy for a particular side. Why then was Darry referred to all the time as the prosecution witness? Rule 19.23d obliges experts to disclose anything that might reasonably be thought capable of undermining their opinion or detracting from their credibility or impartiality. And this transparency allows the court to assess potential biases or conflicts that could affect the reliability of the expert's testimony. Not the jury, the court. Evans repeatedly put into evidence facts that were not facts because the court allowed him to do so. And I would ask anyone listening to this, would you be confident of Darry Evans turning up at the cut side of your newly born baby? Would you believe that he had the competence, the integrity and the professionalism to look after your child? And do you think that every doctor who finds himself in that extraordinary position of privilege in other people's lives must, like Caesar's wife, be above suspicion and cannot carry with them, especially in public life, even the slightest whiff of corruption? Yes, doctors are humans. They do a difficult job. They make mistakes all the time. But there's no obligation on any doctor ever to become an expert witness. But if they do, the same rules apply to the witness as would apply to the practicing doctor when it comes to the truth. And there's a fair way to go in this affair before we actually get to the truth. The Lucy Letby case is an extraordinary case for many, many different reasons. And it's likely we'll never really know what happened. But how the hell are you ever supposed to win a court case that is based on mere circumstance that is relatively easy to brush aside if you have an expert who will stand up and tell the jury the truth? One would think that that isn't too difficult. And in that regard, I think one would be very wrong. So we'll resume in the next episode with paragraph 111, ground one discussion, where the appeal court judges are going to tell us what they think of all of this. I've certainly had my eyes open by this trial and this appeal court ruling, and I hope you have too. So we'll see you in the next episode. Bye.